Hello, everyone, and welcome to another segment of Armed with Knowledge. I'm here today with Eric Otstepenis, and Eric is the legal counselor for the Massachusetts Chiefs of Police. He's also a staff instructor with the Municipal Police Institute and a well-known contributor to the International Association of Chiefs of Police. Good to be with you again, Eric.
Nice to be here, sir.
So we're going to talk about a couple of cases here that are found in the MPTC student guide as part of your legal updates training. And the first case I want to talk about is Commonwealth versus Tsosis. And that's a motor vehicle arrest case. It involved a hotel parking lot, actually, down on the Cape in Falmouth. And what took place there was the security guard was in his booth and he noticed a pickup truck pull into the parking lot of the hotel, which houses a restaurant, a shop, and a public beach as well. And the truck was pretty loud, and the security guard approached Mr. Tsosis to talk to him about, what are you doing here? Can I help you out with anything like that? And what occurred was Tsosis got out of the vehicle, and he was very threatening in his gestures, and he frightened the security guard, and the conversation wasn't going well, so he called the police. And upon their arrival, they made some observations of Mr. Tsosis, and they determined that he's possibly operating under the influence of alcohol. They did some sobriety tests and arrested him. As a result, he was found guilty, and he appealed. And his basis of the appeal were two things. One was the fact that he felt he was operating on private property. So I would like you, Counselor, to just refresh in our minds the elements of an OUIL, if you would.
Sure, yeah. So obviously with OUI liquor, we're looking at operation of a motor vehicle on a public way while under the influence of intoxicating liquor.
Sure.
For this case, and what's kind of interesting about this case is that our focus is not on the operation aspect or on the intoxication or being under the influence aspect. What the focus is really on where he was operating. Was it a public way? Now, Mr. Tsosis argues that, hey, look, this is private property. I'm on the Seacrest Hotel beach property, sure. And so look, this isn't a public way. Now, interestingly enough, we have to look at what this property looks like, and all of our officers in Falmouth are going to know exactly what we're talking about. But when you get to the Seacrest property is obviously a hotel, but it has a bar, it has restaurants, it's got different shops and stuff, and then there's a public beach there as well. So although the hotel itself may be private, there are many elements to the hotel that makes it public. Yes. Now, when you go to the Seacrest, you pull into the parking lot, there's kind of like a little guardhouse, if you will, or guard shack. And it says something about like guest check-in here. So when guests go to stay at the hotel, they traditionally stop at that little booth and check in and whatnot. But everyone else, all of the other visitors who go to the bar, who go to the restaurant,
sure,
who go to the beach,
sure.
They don't stop there. They just go right through. And in fact, this little guard booth isn't even manned most of the time. There's only a few situations that it is. So looking at this case, it wasn't a case where there was a clear a guard booth that established what we may call like as an anchor point to stop somebody from getting in, right? This was kind of like some people stopped, some people didn't. Sometimes it's staff, sometimes it's not. And the entire public has the right of access to be there, to go visit the restaurants, the hotel, the shops, the beach and whatnot. So the court found all of those factors to be highly determinative in making the ultimate decision that he was operating on a public way. So that's really the takeaway from this case. So taking it one step further, David, for all of our officers out there, kind of think about your own town, your own cities. Think about what kind of properties within your jurisdiction may look something like the Seacrest. And consider that now moving forward, that if you were to stop somebody on that property, would you consider that to be public or private, and why? These were the factors that worked for the Seacrest, and forever, Falmouth officers are going to be able to rely on this case to establish stops within the Seacrest as being, or within that property as being on a public way. So think about how you can use this case in your jurisdiction and how you can be able to articulate whether or not areas in your jurisdiction may be public or private based upon these factors.
So all of that is very important for the conclusion of this case. And for you officers, I would remind you that when you make a motor vehicle stop and you're considering charging, operating under the influence of alcohol, your elements are consistent whether you're in your town or in this case, in the town of Falmouth. You need to have operation of the motor vehicle. You need to have that to be on a public way, and it was determined that the Seacrest Hotel parking lot was in fact a public way, and you need to have impairment, and they had no trouble proving impairment. So a takeaway too is a public place is not solely a place where the public is allowed to park, but it's also a place that the public are allowed to visit. Right. So we're going to move on now to another case, Commonwealth versus Proya.